I'd like to bring up Chief Judge William. Thank you, everyone. We're going to get started now. We're pretty much on time. We're going to begin by introducing the team from 36th District Court that helped make this historic day and this historic document happen. I want to begin by introducing my original General Counsel, Mr. Saul Phillips, my now General Counsel, Sean Chakay. I'd like to introduce our lawyers, our outside counsel from Dickinson Wright, Mr. Scott Petz and Sobo. I'd also like to introduce our local counsel, Mr. Gerald Evelyn. I'd like to introduce Judge Larry Williams. I'd also like to introduce the Honorable Sheriff Raquel Washington. We are also joined by other outside entities that will help implement this plan. Christine Longstreet, Managing Director from the Neighborhood Defender Service Office, Attorney Aaron Keith, Managing Policy Director from Detroit Justice Center, former Judge Ruth Carter and Ron Rolando from Michigan Indigent Defense, and they're our coordinator and deputy coordinator. Attorney Joyce Riesenauer, President of the Misdemeanor and Felony Defenders PC, and Attorney Phil Reagan, and of course the Honorable Eric Holder, former Attorney General of the United States, and Saul Green, who will be serving as our community partner, and you'll hear more about that at a later time. At this time, I'd ask if Phil Mayer come to introduce the ACLU.
Thank you, Chief Judge McConaughey. I'd also like to introduce some folks on this side. First and foremost, our clients who helped bring the lawsuit that has led to today's agreement. Starmaid Johnson, Timothy Lucas next to her, and Kushan Moore Jr. In the back. We also have other clients not able to join us today. Devonte Ross, Keith Wilson, Asia Dixon, and Katrina Gardner. Those of us representing the plaintiffs, I'm Phil Mayer, Senior Staff Attorney at the ACLU of Michigan. Also here is Dan Korobkin, our Legal Director at the ACLU of Michigan, and Lauren Kogali, the Executive Director of the ACLU of Michigan. Brandon Buskey, the Director of the Criminal Law Reform Project at ACLU National. Twyla Carter, the National Director of Law and Policy for the Bail Project. Amaya Trigg, Senior Counsel at the NAACP Legal Defense and Educational Fund. Aaron Lewis from Covington and Burling. Marta Cook from Covington and Burling. Again, thank you all for being here. This is a historic day for Detroit, and a day that will be important for justice in the city for years to come. For decades, thousands and thousands of people, presumed innocent, were needlessly locked in jail simply because they were too poor to pay bail. The cash bail system was originally intended to ensure that a person returns to court to face the charges against them. But instead, throughout Michigan and the nation, it has morphed into mass incarceration of the poor. It punishes people not for what they've done, but for what they don't have. It's a system that has devastated families and communities, separated parents from their children, caused people to lose their jobs and housing, and has wasted millions of dollars in taxpayer money by keeping people who have not even been convicted of a crime locked in jail when they should be at home. Today, we're putting an end to this unjust, unfair, and discriminatory system here in Detroit, thanks to our leaders at the 36th District Court, who have been willing from the start to come to the table to improve this system. And thanks to our clients, who've had the courage to join our lawsuit so that others would not have to endure what they experienced. One of those clients who was not able to be here today is Katrina Gardner, a single mother who was arrested and charged with disorderly conduct because she had a disagreement with a teacher who she didn't think was doing enough to prevent her child from being bullied. Ms. Gardner was ordered to pay $630 of bail to be free while her case was decided. She couldn't afford that, so she wound up having to use the rent money to get back to her children who were being looked after in an emergency by a family member. As a result, she was kicked out of her residence, had to move around for months, including staying with a family member in a house that was far too small for all of them. It's a period that inflicted pain and inconvenience on both families. Ms. Gardner never had to serve a day in jail for the actual offense, only for not being able to afford bail, and her family is still recovering economically years later. Ms. Gardner's situation, unfortunately, is typical of a nationwide problem of courts using cash bail to lock up poor people and people of color who have not been convicted of any crime. Studies have shown that this widespread misuse of cash bail makes communities less safe because of the devastating impact on people, families, and the community, and it does nothing to reduce failures to appear in court and forces people into pleading guilty to crimes they did not commit so that they can get out of jail faster. For years, the ACLU observed courts throughout Michigan and saw the same problems throughout the state, including but by no means limited to here in Detroit. In April of 2019, we brought a lawsuit against the 36th District Court here in Detroit, not because they were necessarily the worst court with respect to bail, but because a single lawsuit here had a chance to impact the most people, as the 36th District Court is by far the busiest in the state. At the time, people in court at their arraignments did not have attorneys. We know that there's a better way. In most cases, release conditions can fully protect the public, and simple interventions like text message reminders and rescheduling non-urgent hearings can address the problems that make it hard for economically precarious people to get to court. Instead of litigating aggressively, the 36th District Court, now under new leadership, sat down with us to find a way to resolve the problems of the bail system in a way that protects both the public and the individual rights of people accused of a crime. This agreement today, these efforts culminated in the signing of a historic and path-breaking agreement, creating a partnership between the civil rights organizations and law firms represented here today, our clients, and the 36th District Court. Under the agreement, judges will not impose cash bail without first making a finding about how much the person can afford. And anyone at 200% of the federal poverty line or lower will be assumed not to be able to afford bail. Only when there are individualized reasons to believe that a person is a flight risk or a danger to the public will judges impose cash bail at a level that can keep that individual in jail. As a result, both sides of our partnership have agreed that locking a person in jail before their case goes to trial will be the rare exception rather than the rule, and that the result should be that people are only incarcerated before trial at low rates, consistent with other jurisdictions that have successfully reformed their bail systems. Every person facing criminal charges will have access to a lawyer at their arraignment and the chance to consult with that lawyer before the arraignment to prepare their arguments. This agreement today creates a partnership between the 36th District Court and the organizations represented here today to work to make sure this agreement comes together and is implemented as envisioned. And it establishes Saul Green, a former U.S. Attorney, Deputy Mayor, and Civil Rights Advocate, as our community partner to help resolve any differences that may emerge between the 36th District Court and Plaintiffs' Counsel going forward. With that, I'd like to turn it over to my partner, Chief Judge McConico.
Thank you very much. Yeah. We're having a few mic issues, so I'll try to yell a little bit. Again, my name is Bill McConico. I'm the Chief Judge of the 36th District Court, and I am proud to be here today to announce the agreement that the court has reached with the ACLU in an effort to reform our current cash bail system. This groundbreaking initiative has been in the works for 3 years and will result in the justice system being more equitable and in an objective fashion. No longer will being poor result in disparate justice. This agreement preserves judicial discretion while ensuring that judges are exercising that discretion lawfully and wisely. Conversely, this agreement will ensure that people who do not pose a threat to public safety or a flight risk do not remain in jail due to unaffordable bail, which has historically created a domino effect of lost work, housing, and other challenges. It also ensures that the pressures of being in jail do not result in coerced plea bargains. We also expect this agreement to increase the rate of court appearances, enhancing our existing text reminder program and by giving those charged with less serious offenses additional chances to appear before the issuance of a warrant. Reforming and revising our approach to setting cash bail also aligns with our state's criminal justice system. The Michigan Joint Task Force on Jail and Pretrial Incarceration, co-chaired by Chief Justice Bridget McCormick and Lieutenant Governor Garland Gilchrist, with the help of the Pew Charitable Trust, conducted a 10-year review of our system, and which showed that many people in Michigan are in jails awaiting trial or serving sentences for low-level offenses that pose no risk to the public. In many cases, these individuals were held a month or longer. These levels of incarceration cost Michigan counties nearly $500 million each year. Last year, our legislature enacted 20 reform bills to reduce jail populations and to help people avoid being held in custody for low-level offenses. We believe this agreement will serve as a model for courts in Michigan and indeed throughout the nation. It is possible to develop policies and practices to reduce unnecessary incarceration associated with cash bail while still protecting the public. And I want to repeat, we are able to revamp the cash bail system while still protecting the public. Again, thank you for everyone for coming and being a part of this historic endeavor. At this time, I want to bring up Judge Larry Williams. And before Larry comes up, when I was appointed Chief Judge November 22nd of 2019, and I was to take office in January 1 of 2020. Judge Williams contacted me 48 hours after the appointment to meet with me on a Sunday morning to talk to me about this lawsuit. He wanted to stress to me that I could not wait to January to get up to speed on what was going on with this lawsuit and the importance of working on this from day one. Judge Williams has been a part of negotiating with the ACLU and all of his partners from the inception of this lawsuit. And we would not be here without the yeoman's duty and the work of Judge Williams. Judge Williams, I'd like to thank you again for your work and ask you to come say some words.
First and foremost, thank you everybody for being here. And I want to start by thanking Chief Judge McConnell for the leadership that he has provided to this court and continuing our work with our partners at the ACLU. Is this working?
Yeah,
I'm sorry. I'm not used to talking on the microphone, and I'm just going to be honest, my briefs are going to be brief. We have a lot of speakers up here who are doing the important work of explaining what this agreement is going to do, but I'd just like to take a moment to highlight some of the things that are going to happen because of this agreement. When we came to the table 3 years ago, there was a recognition on the court side that there was a problem in the way that we conducted these arraignments. There were people being in custody who shouldn't be in custody. Small level offenses, civil infractions, traffic offenses, and even more serious offenses where our intention was not to hold someone in custody, but to make sure that they showed up to court and that the safety of the community was protected during the time of this, that these cases proceeded. And with that going into this, and with that understanding, and with the help of our partners with the ACLU, and with the Bail Project, with the NAACP Defense Fund, we've crafted an agreement that not only starts with the premise that most people are going to be out while they're awaiting their sentence, that cash bond is rarely used to make sure someone comes to court. But at the same time, we've protected the judicial discretion to make sure that we are able to do our jobs. This agreement calls for not only counsel at arraignments and following the guidelines and the measures set forth by the MIDC, we're making sure that arraignments become a substantial hearing, where folks have the opportunity to speak with a lawyer, have their understanding of what their case is going to be, and learn what an affordable bond, if any, started our text message system to remind people when their cases are up. And the only thing else that I want to highlight that as a result of this agreement as well, we're starting the process of being a transparent. There are going to be statistics every year going forward, every year going forward, explaining what we're doing in this court, who's affected by the bonds that we're setting in this court, and what this looks like. So, happy to be a part of this. I'm happy to work with the folks on the other side. I'm happy to continue the work that we have to do with this court to make sure that everyone's rights are protected and to make sure that the 36th District Court does the best job as possible in protecting all of its citizens. So thank you all very much.
Hello. Sounds like it's working. Okay, again, just wanted to do a little housekeeping that we'll take questions at the end. Apologize for the microphone issues. If anyone needs to put a mic up here before we move on, feel free before we move on. If not, I'm going to bring up Starmaine Jackson. Did you want to? Okay, Phil is going to read a statement from Starmaine. Starmaine is here.
Starmaine Jackson, one of our clients, would like to give the following statement. Her words, not mine. The nightmare I endured in 2019 began after my arrest on a misdemeanor charge related to an alleged domestic dispute. This was my first time being arrested, so the experience was entirely new to me. Appearing before a judge in a bail hearing was confusing on so many levels. With it happening so quickly, I didn't know what was going on. I really needed to have an attorney with me to explain what was happening, but no legal representation was provided. I was completely on my own. When the judge decided that I needed to come up with $500 cash in order to await my trial as a free person, I was never asked if I could afford that amount. I couldn't, and I was sent back to my cell. At the time, I had 2 kids who were here, 4 and 2 at home. I had never been separated from my children for any length of time. It was a devastating experience for all of us. Not being able to humble them, even for 1 minute on a 5-minute phone call, was torture for me and my kids. My children experienced extreme separation anxiety. When I was eventually released, they were afraid to let me out of their sight, worried that I would be taken from them again with little or no communication. Luckily, I had friends and family, some of whom are also here today, who cared for my kids. They were also able to come up with the cash so that I could get out of jail, scrounging up money, borrowing money from their friends and family, $10 from one and maybe $20 from another. This means coming up with the money for bail was a financial and emotional burden for all of us, especially me. Unable to call into work, I lost my job at a nursing home. And because I could not pay my rent, I lost my home. It took me months to recover financially. The emotional scars and burden remain for me and my children. No one should have to go through what my family and I have had to endure just because they live on a low income. Now, because of this historic agreement, countless others will be spared the hardships of being locked up just because we are poor. This is a great day and a great victory that I'm extremely proud to be part of. Now, because of this change, this historic agreement, thousands of us will be spared. We've succeeded in making the criminal legal system in Detroit more fair and just. The next step is to continue the much-needed changes announced today. For me, the issue of a person's freedom is so important that I named my newborn daughter, who I think is maybe over there, Liberty. With apologies that you're hearing my voice, another client of ours, Devonte Ross, who was ill this morning and not able to make it, also has a statement, and I will read his statement for him. 3 years ago, I was arrested for failing to appear in court after I received a ticket for being in a city park after dark. When I appeared before a magistrate for my bail hearing, it all went very fast and confusing. Cash bail was set at $200. I was never asked if I could afford that amount, which I couldn't. So I had to sit in jail for a week it could have been longer, I was only released due to overcrowding at the jail. Jail is a difficult place to be because of the constant noise. It's difficult to sleep, the food is not good, so it's hard to stay healthy. It's just a scary place to be because you never know what might happen. Being in jail for even a short period of time can have a lot of negative impact. For me, it was devastating. I missed out on getting a job because I couldn't go in for an interview that had been set up. Even worse, I was unable to attend a custody hearing, setting off a chain of events that led to me losing custody of my 2 children, one of whom was 2 years old at the time. My youngest was only a few months old. It took 2 years before I was able to regain custody. That is time lost that I will never get back. I missed celebrating Christmas and birthdays with them. I missed my daughter taking her first steps. Losing your kids like that is like having your heart ripped out of your chest. So a week in jail cost me 2 years of my kid's life. I never had to serve any jail time because of the ticket, only because of bail. Emotionally, it was very difficult to deal with. Just functioning was hard. At times, I even considered suicide. Fortunately, I was able to survive and get my life back on track after a year or two, and now I have a steady job at a sandwich shop. I've been reunited with my children, and things are finally looking up. Someday I hope to tell them about this case and the role I played in it. I hope they will be proud of me because of what this agreement accomplishes. It's incredible. No one should ever have to sit in jail and have their world turned upside down just because they're too poor to buy their freedom. Hopefully because of this, no one else will ever have to go through what I went through.
Thanks, and again, apologies for the issues with the speaker and the microphone. The good news is we have lots of written statements that we can give you at the end that you can take with you. So I appreciate your patience. Obviously, this impacts different degrees and aspects of the system, and so we thought it would be important to hear from the law enforcement side. So with that, I'd like to bring up Wayne County Sheriff Raquel Washington.
Thank you, Darcy, and thank you all for being here. I count my honor to be able to stand here on this historic day because I believe in this day. I believe in this agreement. I have a few words that I'm going to read to you, and then I'm going to take my seat. So as the top law enforcement official of Wayne County, I believe it's important that our decisions are guided by discernment and compassion. I support limiting the use of cash bail, low-level offenses because it incorporates both of those approaches. This agreement keeps people out of our jails who shouldn't be there, that we wouldn't want to see there simply because they can't afford bond or misdemeanors such as family violations. This will give some relief to the citizens who wind up spending too much time in jail simply because they can't pay. This agreement will allow people charged with low-risk offenses to return to work and family. This will give some relief to our deputies who are burdened with processing individuals who don't pose a public safety or flight risk. That means we can also devote those resources to other needs in our 43 cities and townships. This is historic. This is much needed. This is going to give the relief that we need even in our jails to our deputies, as well as the taxpayers and citizens of Wayne County. So thank you all for putting us on ACLU and getting us to this place, and we look forward to a continued relationship and making sure those who should not be incarcerated in our facilities are not incarcerated. Thank you so much.
Thank you, Sheriff Washington. And now, without further delay, I am very honored to bring up the former U.S. Attorney General, Eric Holder.
Well, good morning. I didn't know that Detroit was also the Windy City, you know? I'd like to begin by thanking Chief Judge McConaughey and the judges of the 36th District today for inviting me to join you all here today. It's good to be with new colleagues and also with old friends, my man Saul Green. This agreement reflects a fundamental truth at the heart of my public service, both as Attorney General, but also as a judge in Washington, D.C. We can promote fairness in our criminal justice system, and we can protect public safety. In truth, we have to do both. Far too often, these two goals are presented as competing interests. This is particularly so regarding efforts to reform bail or pretrial detention. But this is a false choice. There is not a tension between the two. For more than 60 years, since my predecessor as Attorney General, Robert Kennedy, convened a national conference on bail and criminal justice, the evidence has been clear that imposing unaffordable cash bail causes far too many people to suffer incarceration before they've had their day in court, not because they are guilty, but simply because they cannot afford to post bail. This is something that Bobby Kennedy was concerned about at the beginning of his time as Attorney General of the United States in the 1960s. The practice that we are dealing with here today harms defendants, their families, but it also harms our communities, and in particular, communities of color. And as a result, it further risks eroding the public's trust in the criminal justice system. Now, we know that there is, in fact, a better way. More than a decade ago, I, as Attorney General, convened a national symposium on pretrial justice. I noted then that the evidence showed that almost all pretrial detainees, including myself, could be released and supervised in their communities and allowed to pursue or maintain employment, participate in educational opportunities, and their normal family lives without the risk of endangering their fellow citizens or fleeing from justice. It was true when I said that in 2011. It is true today in 2022. This agreement that we are here to announce and I think to celebrate preserves the ability of judges to consider whether a particular defendant, based on an individualized determination, presents a danger to the community or a flight risk. This is how our system is supposed to work, but has not worked too frequently in far too many places. Let me quote one other person. Chief Justice Earl Warren once observed, and I quote, "The quality of a nation's civilization can be largely measured by the methods that it uses in the enforcement of its criminal law. And those methods result in arbitrary inequality based on race, indigence, or otherwise, the nation as a whole suffers, as well as those who are victims of inequality," unquote. Eliminating this inequality is the work that I have tried to do during my career. It is the work that I continue to try to do to this day. With this agreement, the 36th District Court has marked itself as a national leader in criminal justice reform. And it has embraced the opportunity to prove the truth that I've known for so long. We can both promote fairness in the criminal justice system and protect public safety. In truth, we must and shall do both. Thanks very much.
Thank you. Thank you very much, Attorney General Holder. And thank you, everyone, for being here, to all our speakers, to all the people that played a role in this historic agreement. And at this point, we'll take your questions. By the way, we were worried about rain today, so we didn't know it was going to be windy. So at this point, we'll take your questions. And it'll probably be a combination of folks answering. So, yes.
The agreement will be in place between 2 and 5 years, depending on a number of metrics about how things go from here. We're all hopeful that it will be shorter because of its successes.
Yeah, George.
I have 3 questions. I'll ask the easiest one first. If you guys don't know, was BPD in the Wayne County prosecutor's
The Wayne County Prosecutor's Office and DPD, they were not part of the negotiation of this settlement. We have had talks with both concerning this agreement, but they were not at the table. They were not consulted. The Wayne County Sheriff's Department runs the jails, and this is concerning pretrial detention and bonds going forward. So the sheriff's department was the partner in that, and that is part of law enforcement.
The second question is, does the department, are they already open for criminal indigent defense? If you're asking to have a lawyer at every hearing, is that possible?
Absolutely no. It will not place the word. The indigent defense system has been funded fully right now by the Michigan legislature. We have started our MIDC program at the beginning of 2020. That's why we have our director and deputy directors. They're standing behind us. We have our defense, misdemeanor defense organizations. They're up here also. And we are doing this right now. We are going to ensure that the stories that you heard from 2019 and 2018 of people having arraignments, not having attorneys, that is no longer the case. There will be an attorney at every stage of the criminal justice system, and that will be funded.
And finally, Judge, we spoke about this briefly before. There's been a string of stories about folks who these things were in place. The judge was supposed to look at their criminal background, despite in many cases them having several violent crimes, convictions, and then they violated their bond, and they were then again released. We've done all the stories, we've seen it. What specific measures have been done about loosening on the other end to make sure that doesn't continue to happen?
And as we stated in the last interview, I had a discussion last night, not dealing with this lawsuit, but dealing with how we're doing our pre-trial stuff with our prosecutor, Kim Worthy. One thing that I have supported, I've talked to our county executive, we've talked with our sheriffs, we have to have funding for the Wayne County Prosecutor's Office and the Third Circuit to make sure there is a person at every arraignment that can pre-trial services, that can have the information of the criminal background and history of a defendant, as well as a bond recommendation. We need to make sure all magistrates and judges have the most information possible to give a decision based on relevant facts. Where you have a situation where a person has a criminal history and that history is not presented to the magistrate at the time because there's not an officer, there's not a prosecutor there to give that information, and the magistrate can only work with what they have. They cannot guess dangerousness to society or flight risk. They have to go by what's presented to them on that hearing. That is an ongoing process. We're going to make sure that's beefed up, and we're all on the same, whether it's defense, whether it's prosecution, whether it's law enforcement. We want to have more resources, that the magistrates have every tool at their disposal at arraignments to make sure they're making correct decisions. But unaffordable bail no longer will happen in the city of Detroit versus District Court.
To top off two of those answers, in terms of attorneys at arraignment, investing in attorneys at arraignment is an investment in the community. You heard the stories of the economic devastation that affect not just the families, not just people accused of crimes, but their families, the community. Having attorneys at arraignment, in addition to the fact that funding is provided at the state level, is simply smart money. With respect to bonds, the agreement today focuses on public safety. It ensures that judges are focusing on what they should do, which is an individualized inquiry as to whether or not someone presents a flight risk or a danger to the public, rather than trying to impose arbitrary amounts of cash bail. This agreement is about promoting public safety, and public safety is promoted by cash bail. Under the agreement, the judge will inquire in every case in which cash bail is being contemplated how much the person can afford. There will be an assumption if the person is at 200% of the federal poverty guidelines, which is about $55,000 for a family of four, that the person cannot afford to pay cash bail, and that's consistent with what we know. The Federal Reserve has repeatedly found that about 40% of American households can't afford a one-time $400 charge. Like a broken car or something like that. So that's what we're capturing in this agreement.
not a limit. If again, it's dangerous to the community, possible risk is the nature of the offense, and there's the flight risk. So a person that's making $100,000 that's charged with a nonviolent offense or it's a traffic offense, they should not have a cash bond either. So there's not going to be one set for poor and for rich. However, right now our present system, there is a difference, because if you give a person a $200 bond, most people here, that's affordable, but that's not affordable for everyone. So it's bringing the equity the other way. But no, this is not saying that if you have the money to pay the bond, we're going to make you pay a bond. It's based on whether you are a danger to the community or whether you pose a flight risk. Well, I actually have made a joke with Phil also that if you would have just waited a few months until I became chief, we kind of could have sat down and worked this out without all these lawyers standing around. But you know, sometimes pressure pushes things. That's why in negotiations, a lot of times contracts are settled right before the deadline. I can't speak to why we were here in 18 and 19, but I can say that starting in 2020, we started working together as a collaborative, the court, the community partners, law enforcement, and that's why we're here.
You know, I'd also like to, in response to that question, one of the points I made in my remarks, which is when we brought this lawsuit, what we were observing, it was by no means limited to the 36th District Court, and the 36th District Court was by no means the worst court in the state. The use of cash bail, the knee-jerk use of cash bail, the inequities that it causes is unfortunately widespread throughout the state. We believe that the agreement today that we've reached with the 36th District Court in partnership is a model for how courts should reform elsewhere. There is legislation currently pending to reform cash bail in Michigan at a wholesale level. We hope that legislation will move. It hasn't yet been given a committee hearing. If not, we will be looking at litigation alternatives elsewhere, using this agreement here today as the model that it justly should be.
All right, are there any more questions before we wrap up? Yes, absolutely.
One thing I want to make clear, this is not something that is truly novel. When I was a judge in Washington, D.C., we have the same system in place there. And we have done studies that show that the system that has been put in place by this agreement does not have a negative impact on public safety, does not have a negative impact on people coming back to appear. This system works, and this is a system that needs to be, I think, implemented nationwide. The recognition that this is a problem goes back as far as I said in my remarks, back to Bobby Kennedy in 1962, when he brought together a symposium to look at our bail laws, and I closed on again in 2011. But I want to assure the people of this great city that which we're talking about today has been implemented in other parts of the country, and it simply works. All right, now I'm going to go off script here. You all there's a couple of things. First off, we have a reflexive reaction to the notion of lowering bail. Somehow people equate bail with safety. The studies, the empirical studies, don't show that that is in fact true. The other thing, we did this in Maryland, is that there is a bail industry that opposes these reforms and uses its weight in the state legislatures, local city councils to oppose these reform measures. And so the combination of those two things, a reflexive notion that somehow, some way, if we have bail, we're going to keep the American people safe, which is not empirically shown to be true. And the bail industry, which tends to fight these kinds of reforms, I think has kept us from making the progress that Bobby Kennedy wanted to put in place, a successor Attorney General, me, wanted to put in place. And then thankfully, the folks here today are actually putting in place for Detroit.
Okay, we're going to get, just kind of was going to say a few more words and then we're going to wrap up.
And this is a very few words, but I do want to thank the judges and the magistrates of 36th District Court who who are going to be on the front lines of implementing this historic document. Judge King was here, he's still here. Judge Kenneth King, who is presiding of our criminal and felony division. Our chief pro tem, Adrian Hennick Johnson, is out here. We have our legal team in-house here, and all of the employees of the 36th District Court who are going to help process and make sure this is a safe community. So I just want to thank all of the staff and the judges who are going to implement this program.
All right, thanks again so much for being here. Thanks for your patience with all of our glitches, and folks are going to be around for a few minutes for questions. So before we head out. Oh. Yeah, I'm going to get